I'm sure you know this. Day after day, women and girls in India go to court asking for permission to abort unwanted pregnancies. 243 women and girls went to court seeking permission to abort between May 2019 and August 2020. 112 of them went during lockdown, when access to both health services and legal services were heavily constrained. Now, India's laws allow for abortion on several grounds before 20 weeks, and even after, if it threatens the mother's life. So why did these women have to approach a court for a time-sensitive service? My name is Pallavi Prasad, and here at Newsworthy, we do journalism and just that. Joining me is Akshi, an independent researcher who recently dived deep into the findings of a forthcoming report by Pratigya campaign that gave us that figure of 243. She did this for a story for India Spend. But let's begin with a brief context to India's abortion laws. As it reads today, the Medical Termination of Pregnancy Act allows a woman to get an abortion until 20 weeks of pregnancy on certain grounds. Between conception and 12 weeks of pregnancy, a woman who wants an abortion needs the go-ahead from one medical provider. After 12 weeks and up to 20 weeks, at least 2 medical providers are needed for this go-ahead. Let's underline this. The MTP Act only specifies what a woman or a medical provider should do till the 20-week cutoff. Anything above it becomes a criminal offense. And so increasingly, women and girls are approaching the courts for permission after 20 weeks of pregnancy. But it is also important to note that many women and girls end up going to court even before the 20-week mark when they don't need to. Of the 243 cases Pratigya documents, 53 were filed before the 20-week cutoff, while 14 went to court in the first trimester itself. Unclear communication by medical providers or hesitation by them to perform an abortion, especially in the case of minors and or rape survivors, are the reasons. Courts too don't always dismiss these petitions, but most of the time it's just ignorance of the MTP Act. Akshi, can you give us a sense of who the 243 women and girls were?
Sure, Pallavi. So, of the 243 cases that were documented and analyzed by the Pratigya campaign in the report, the 2 most common reasons cited by petitioners were rape in 49% of the cases and severe fetal anomalies in 48% of the cases. It's also important to point out here that 43% of all the cases, that is 105 of the 243 cases, with those where the pregnant person was a minor, and the pregnancy was an outcome of rape in all those cases. So you see, the reasons that were cited when asking for permission to terminate are nothing very different from what is already covered in the MTP Act. Except most of these 243 girls and women went to court because their pregnancy had crossed the 20-week cutoff. So why do women and girls want to terminate a pregnancy at 20 weeks or later? There could be, of course, many reasons for this. Minors, for example, may not even realize that they are pregnant till the fetus starts moving inside them, which is fairly late in the pregnancy, around 18 to 20 weeks. Even for someone else to notice that they are pregnant, it may take up to 16 to 18 weeks for that stage to occur. So you see, by the time a pregnancy is detected and then an FIR is filed, the 20-week cutoff is actually behind the person, and then they have to move the court in case they want to abort. When it comes to fetal anomalies, there are 2 large reasons why the pregnancy may be at 20 weeks or later. First is a medical constraint. There are many anomalies, especially those involving the heart and the brain and the neurology, which are only detected at 18 to 20 weeks. And then the second is related to capacity. You see, at any point in time, millions of women are pregnant in this country. And not all of them are able to access a sonography in time for an anomaly to be detected before 20 weeks. So, what is a woman for whom a severe fetal anomaly has been detected and whose pregnancy has moved beyond 20 weeks, supposed to do?
So clearly the 20-week cutoff isn't working entirely. A draft amendment to the MTP Act that proposes making abortions till 24 weeks legal is currently pending in the Rajya Sabha. At the heart of the MTP Act, however, remains the problem that a woman needs the permission of a third party to abort an unwanted pregnancy at any stage. In the gestation period the MTP Act covers, it's doctor-centric. In the period it doesn't, it's court-centric. The woman has very little say in the process except saying she doesn't want to carry on with her pregnancy. Akshi, what happens to these abortion cases when they reach the courts? Do women have more agency then?
Once a petition is filed, courts appoint a medical board comprising medical experts who examine the pregnant person, and then they give their opinion whether the termination of pregnancy is needed or not needed. Needed being a key word here. Court cases and arguments all show that while the pregnant woman, her safety, her body are all central to these discussions, but her own voice is rarely the one that moves the needle. Instead, the decision is based on the opinion of a group of technical experts whose assessment may sometimes be impacted by their personal beliefs and perspectives. Not all experts will be pro-choice, for example. We must also remember that none of these technical experts will have any stake in the pregnancy beyond this decision. Among the 243 cases documented by the Pratigya report, one case that stood out for me, for example, was one from the Madhya Pradesh High Court where permission for abortion was not given. This was a case filed by the mother of a 13-year-old rape survivor who was 26 weeks pregnant. In her petition, the mother argued that the pregnancy was causing severe emotional and psychological trauma to the child and hence permission be given for abortion. When the medical board examined the child, the psychiatrist on the board argued that the child was only feeling anxiety at times and he didn't think the situation was severe enough that a termination was needed, and hence permission for an abortion was not given. So you see, coming to the amendments that are currently pending in the Rajya Sabha, if passed, they will provide for setting up of permanent medical boards in each state to decide on these cases for abortion. Now, experts warn that this is just going to be a way of formalizing third-party authorization for abortion, something that the WHO, the World Health Organization, has consistently said that it violates the rights of girls and women. Instead, what we need is a rights-based law and a rights-based approach where the woman is at the center of all decision-making.